We are in open session, Mr. President.
Thank you very much. I had just indicated that we had concluded discussion on the item of commencement of trial tomorrow in terms of any foreseeable difficulty with commencing the trial tomorrow. And we go next to the item defense application for reconsideration of a witness preparation decision for an oral ruling. And we render the ruling now. This is the defense application for reconsideration of the 2nd of January 2013 decision on witness preparation. On the 26th of August 2013, the defense team for Mr. Ruto filed an application requesting the trial chamber to reconsider the decision of the 2nd of January 2013 concerning witness preparation, as well as its accompanying protocol. The application aims to disallow the full operation of the witness preparation decision and its accompanying protocol in relation to the prosecution's preparation of its 8, as the defense describes it, core witnesses for the testimonies of those witnesses. As an alternative prayer, the defense requests that the prosecution's preparation sessions with these 8 witnesses be completed before the first of the witnesses begins to testify, and that no further substantive contact be permitted thereafter between the prosecution and the witnesses. In their submissions filed on the 30th of August 2013, the Sang defense supported the Ruto application. The prosecution responded on the same day, opposing the application. The application of the Ruto defense is premised on the argument that certain facts were not known to them at the time that witness preparation was argued by counsel as a matter before the chamber and considered by the chamber. Had those facts been known at the time, the argument goes, they would have affected the chamber's decision on witness preparation. Trial Chamber 1 has held that decisions can be varied if they are manifestly unsound and their consequences are manifestly unsatisfactory because, for instance, a decision was made in ignorance of relevant information, unquote. This is, of course, a sensible proposition. In arguing that the witness preparation decision was based, at least in part, on specific circumstances unique to the situation in Kenya, circumstances which the new facts they now aver apparently contradict, the defense relies on 2 sentences in the reasoning of the witness preparation decision. Those sentences are, quote, in the present case, witness preparation is even more crucial as a means to protect the well-being of witnesses considering the specific situation in Kenya, unquote. And, quote, those witnesses from Kenya who have expressed strong concerns in connection with their testimony are likely to benefit from such pre-testimony meeting with the calling party, unquote. Judge Ebos did not concur in the witness preparation decision of the 2nd of January 2013 with the need to refer to any, quote, specific situation in Kenya, unquote, reasoning that for purposes of that decision, the chamber had made no specific inquiry concerning, quote, specific situation in Kenya, unquote. In the view of this chamber, a fair reading of the witness preparation decision does not make these two sentences a critical part of the reasoning for that decision. That is to say, those two sentences were complementary thoughts only. And those two sentences aside, there is nothing else in the reasoning to suggest that any aspect of the decision was contingent upon the existence of specific factual circumstances present in this particular case. Instead, the decision was an expression of Trial Chamber 5's views of general principles of fairness to witnesses and efficiency in the administration of justice. This chamber is thus not persuaded that the witness preparation decision is rendered manifestly unsound or its consequences manifestly unsatisfactory because of any variation in a defense's views or discoveries as to the facts peculiar to this case. The foregoing reasons should amply dispose of the present application, but in fuller measure, the chamber also considers that the concerns indicated by the defense as motivating their application were fully within the contemplation of Trial Chamber 5 when it rendered the witness preparation decision. In particular, those concerns are comfortably accommodated within the safeguards that were built into the witness preparation decision itself and its accompanying protocol. That is to say, there is nothing at all unique about the defense allegations. At this point, they are only allegations against the indicated 8 core prosecution witnesses, as the defense describes them, that is beyond the purpose of those safeguards, such as compels a reconsideration of the witness protection decision in any respect. It is noted in this regard that the defense submitted that those safeguards, quote, were designed to protect against inadvertent coaching or overenthusiastic preparation of a witness by a party, unquote. The chamber rejects that interpretation of the decision. The safeguards were designed to prevent abuses in an unqualified acceptation of the idea. In the nature of things, however, intentional abuses should attract the greater worry of those safeguards. For the foregoing reasons, the defense application is denied in its entirety. That concludes the oral ruling of the chamber as regards that application. I see we have some time left before the obligatory time to adjourn for the day. We have one more matter, and that would be other matters arising. But before we do that, the chamber would adjourn for a brief period of 10 minutes, and then we'll reconvene in 10 minutes.
All rise, veuillez vous lever.